Here. Okay, welcome back, folks. This is Joint Justice Oversight Committee, our afternoon meeting on October 9th. We are going to make a little bit of an adjustment to our 1 o'clock schedule. We're going to start with the court backlog first for an update on that. And then we will go into the pre-charge diversion update. We're trying to accommodate people's schedule. So for the court update for the backlog, in terms of court cases, there's chief superior judge, the state's attorney and sheriffs, and the defender general. I think we would start with Judge Zone. Unless the three of you want to come up at the same time, it really doesn't matter. However you three want to do it.
For one for all. Happy to go. What's your pleasure, Matt?
All right. Good morning. Good afternoon. Tom Zone, Chief Superior Judge.
Thank you. Thank you for accommodating our flipping of the schedule.
Of course. What do you have for questions? Our clearance rate is above 100%. We are working with our partners, the state's attorneys, the defender general, Department of Corrections, to try to, I think it's safe to say, maximize the resources that we have. There are areas that we certainly need additional resources in each of our entities, but we have what we have, and we have to do the best we can with the resources that we currently have. We have times where something may not go right, and we can contact our partners to say, what's going on here? The transport didn't come. Why is that? Or we need a transport, or we need an attorney assigned in this case. And so are the numbers as high as we'd like them to be for clearance rates and getting rid of the backlog? No. Right now, I think it's about 106%. Some courts are doing very well. Others are not. When we look at the micro level, we can tell and oftentimes why some of the courts are not performing where we would all like them to be. And that may be due to transport issues with defense attorneys who are giving up contracts, and Mr. Valerio has to find new attorneys. And so we're trying to, again, work together to try to figure out the best way to move the cases and do justice for everyone in the court system and the public.
Well, I've got two things. One that just came to my attention, and I don't know how this is playing out or not, the case management system. Is there issues with the case management system in terms of being able to bring up the documents electronically while the case is being looked at while they're in court? Can the judge bring everything up, or just take a recess? Do they have to go and maybe get a paper copy of it? Are you hearing any of that? Because that's what I'm starting.
Judges have the ability, while you're sitting on the bench with your computer, to access the entire case file. We have Odyssey/Justice Enterprise, which is the case management system. There's also a separate product that's called Judge Edition, where judges can go and have separate documents so they can be looking at both at the same time, to have the documents come up in two different platforms. As far as paper copies, like every other area of the world, there's some judges who may want to have a paper copy and may prefer to do that, but it's not necessary. The system works. Are there times where any platform might not be working at a period of time? Yes. That may cause delays, but overall, judges have access to the documents that the parties have access to and that we all need to look at for the case.
So you're not hearing anything from judges that there's issues with the case management system and accessing the information they need while they're on the bench?
I have not been told that directly, but I've got a meeting in a couple of weeks and I can follow up to see if there are those types of issues. Again, we all know sometimes our platforms, whatever we're using, whether it's social media or other websites, might not be populating as quickly as we'd like. But as far as systemic problems, I'm unaware of any.
So my focus on the court backlog is a little different than what Judiciary Committee might be, but my focus would be the backup that creates in our correctional facilities with the detainee population and how that's starting to really play out, pushing our numbers higher. I mean, right now we are at about 500 male detainees in our incarcerated population, so a little bit over 800. In our female population, it's half and half. It's about 70 incarcerated sentence, 70 detainees. So that's just taking the detainee population, it's just growing and growing. And I know some of this is, catching up from COVID, that's what everyone says, and also they're tougher cases. But that's where the court backlog fits in on the corrections piece.
When we were here in September, we discussed that the numbers for the pretrial detainees, back in my experience, historic highs. I don't have the document, the statistics from back in 2010, 2009. It may have been higher there, I'm told, but I don't have that information. But since 2019, when I do have the information, we were about as high as it has been, approaching, I think it was 600. I think this morning it was 542. The backlog and the inability to move cases has what you just talked about. That is, if people are in jail, that is problematic because if we can't move those cases, it's going to increase the jail numbers potentially, and yet we're not being able to address those cases for those individuals, the victims, society, to move things forward. One of the dilemmas we face is in the judiciary, we don't do the transports and we don't supply the people in court. We can have judges on the bench. We can have clerks in the court, judicial assistants in the courtroom, and we can be ready to resolve cases. But if we don't have a defendant, we can't go forward in that case. The Department of Corrections has difficulties sustaining remote hearings. They have specific policies and procedures they put out. We don't have the capacity through them with remote hearings that we believe would be ideal. Not a criticism, it's an observation. I understand their pressures. The Department of State's Attorneys and Sheriffs does not have adequate transport deputies to get people to court that we need to come to court. Tim can talk about that in greater detail, of course, but we have times where we have a choice. You can have this defendant for this hearing or that defendant for that hearing. You can't have them both because we don't have the resources. And so that's a difficulty. And when I said that we're working together, there are times that DOC will go out of its way to accommodate something that might not fit the policy because it recognizes that we're all in this together, I think. The same with the Department of State's Attorneys and Sheriffs. The transports will be permitted when it otherwise might not have gone. So we're trying to do that, but that is, I think, one of the biggest issues that we face. Again, getting people to the courthouse who are in custody.
Yeah, I have some questions. So those are the presumably, let me ask the question this way. So the individuals who are in custody, a lot of them are held without bail. Those are more the cases that involve violence against a person. I mean, is it fair to say those are more complicated cases? I know the homicides and the accessory after the fact, all those attempted homicide. But there's other cases in that category. I mean, is that part of the issue with those are the 500 some cases? A lot of those might be held without bail, and those are more complicated. They take more time. Is that fair?
When you say more complicated, parties in felony cases like that are entitled to discovery and to conduct investigations at a level that would not be in a misdemeanor. Unlawful trespass, you don't have the same rights for discovery, depositions and such that you do in connection with an aggravated assault. So yes. So
the increase in the held on bail, and particularly the low bail amounts, which might suggest not as complicated or serious of a case. How are those processing any quicker? Are we getting those people out of being detained because presumably they may not be felonies, they may not have the long discovery process?
That's the goal.
How does that priority get set?
The judges, I generally send out, just a few weeks ago again, sent out a list of anyone who has 5 or more cases pending. And certainly judges should be prioritizing the multiple docket cases as well as individuals who are incarcerated to try to make sure that if there's a resolution, we can move it. If there's not a resolution, we can try to put that case on for trial at the earliest opportunity. And so we're trying to move those cases.
Yeah, and I guess so I could see a case that is a violent or any felony, and it's going to be more complicated, may take more time. I can understand that those may take longer, people may be detained longer. Is there any kind of statistics to show us that the individual who just has a few misdemeanors or that they are being detained on bail because they were a repeat offender? I mean, is there any statistics?
Well, you wouldn't be detained on bail for being a repeat offender. You'd be detained on bail for a judge determining that you are a risk of non-appearance, a risk of flight from prosecution. So if a Department of Corrections does have a document that it can send out, you can see every case, every individual who was detained, what category they are as far as the amount of bail. So you could go and look into each of those cases to say, at what point was bail put on? Oh, well, the person failed. They may have 5 misdemeanor or 6 or 7 misdemeanors, but they never show up for court. And at some point, the court determined that they were a risk of flight to avoid prosecution, and the judge imposed bail, and that's why they're being held. And so you can see that within the individual cases.
Right, and I'm just concerned as far as if the reason for somebody being detained a long time is because it's just a complicated discovery process, and both defense counsel and the prosecutor needs more time, that's one thing. But if there's somebody being held on bail, it's fairly straightforward case. I just want to make sure that the priorities are set to get that individual out of detention, because it's because of the backlog or the lack of resources or whatever, not the complicated discovery process. That's what I'm just trying to.
I understand the question. This is when you're looking at any type of docket. The difficulty that you face when you're looking at a number of cases is the docket. Let's say you have a week of jury trials, you have 5 days, and you have a case where someone is held without bail on a felony. It's a 60-day case under 7553A, and they have to have their case go. It's going to be a 3-day case. You might have a 3-year-old domestic assault case that the defendant is not in custody. That case has been waiting. You may have a case involving child sexual abuse, and that's going to be a 3-day case. And as I said, you have 5 days. And then you have an individual who's being held for 5 unlawful trespasses or retail theft, all misdemeanors. And as the judge and the state's attorney and the defense attorneys in the case, you have to, what cases are we going to try? Well, you try the 60-day case. But you also recognize that the individual in the domestic assault, his case, if it's a man, for instance, if his case was pending for 3 years, maybe there's DCF involvement. Maybe there is a juvenile case. Maybe there's a divorce or family case. And maybe there's a civil case involving housing. And so we recognize that cases may be intertwined with each of our documents. Oftentimes, the case that we are dealing with is tied into other aspects of this individual's life and other people's lives, and you're waiting for it. And so the judges have to prioritize. And while we certainly want to try those cases that you just described, we'll say that I'll call them low-end misdemeanor cases. When push comes to shove, there are times where we have to make that decision that case is not going to take precedence over the domestic assault or the 60-day case, and we don't have time. So in some courts where we have the resources, we've added an extra week of jury trials to try to alleviate that. But those are the tensions that we have because the case is either, if it's a simple case, it's either going to be a 1-day trial, which still requires the jury selection and the date for the trial, or the parties can resolve it.
So there are a lot of factors for figuring out the priority. I just mainly was wondering about the liberty interest of the individuals being held on bail. They're not paying bail. And it sounds like that is a factor that's
absolutely
more than many other factors. So just turning to something slightly different, but I think related to what we've been talking about, I understand with those cases of individuals in custody, it's getting them to court, the idea of having a defendant in court. For those who are not being held, I have heard that there's a similar problem of no-shows. And that if you could confirm that, in fact, the courts are seeing that as an issue, that, getting these cases moving requires the individual to show up, those who are not being held in custody. How big of a problem is that? And is there anything that is being done, maybe the pretrial supervision program, but anything else that could be done?
Well, the court certainly needs to have the individuals there to move forward. Is it a problem? Yes. Throughout the courts, there's times that defendants don't appear. The court issues a warrant. I think it's safe to say that when you look at a number of the lower end cases, you may very well find that the individuals who are being held are individuals who you just described who aren't showing up for court. And so the court may impose bail to assure their appearance and assure that they don't flee. And so it is an issue. It's one we're trying to address with I know the defense attorneys try to contact their clients and get them to court when necessary. The prosecutors make their arguments as far as someone not be the appropriate resolution. And the other important aspect is when someone does show up, to try to provide an opportunity for resolution. If someone is there and the attorneys are both there, it should be an opportunity to try to resolve the case if there's a chance. If there's not, we understand that the case needs to go on the jury trial list and go from there. But if there is an opportunity, we have an obligation to try to see if the parties can reach it. And as a court, to not push it down the line, but to say, okay, you reached a plea agreement, let's try and take it up today to try to make sure that we can resolve the cases.
That's my last question I have is just what remaining levers do we have as a legislature that help in addressing these issues?
How much time do we have?
Well, we have levers that we
I think that there's a number of areas. I can put together a list of different things, but it's really the things we've been talking about. It's how do we address the transport issue? What are we going to do about remote hearings? Are we going to have work crew again? Which some may think it works, some don't, but our view has been that work crew is something that does help to address cases. A number of different things like that we've talked about that we just need to see is there a way to address it? The best thing we can do is keep the lines of communication open, that when we identify areas that we need assistance on, that we can let the legislature know. We can talk to our counterparts and the executive branch to try to figure out how do we address this, because it's a problem for all of us.
How about the pretrial, the folks who are not in custody pretrial, the no-shows, are there any additional levers there?
The one lever that's been used has been if someone doesn't show up when they're apprehended. My understanding is there's a number of individuals who have bail imposed. The legislature amended 13 VSA 7551 a few years ago, 2 years ago, to say that the $200 maximum amount for bail did not apply for someone who was on conditions of release or on release from a pending case. So I think that's something that lets you know where the person is. If they post bail, ideally it works and they will show up after that.
Thank you.
Other questions from folks before we move on to the state's attorney? Okay,
Thank you.
thank you. So we can have, we can have both, you folks, both Matt and Tim. You want to both come up, or Matt?
I'm going to share my screen if that's okay.
It's fine.
Thank you for being here. No, you didn't have a choice. Tim Leaderson at the Department of State's Attorneys and Sheriffs. And some of you have seen an iteration of this presentation for a while now. This is from May. I want to emphasize May 1 snapshot. We don't have full-time statistics or data staff in our department. So we do essentially a quarterly data pull from Judge Zone's judicial staff that we work very closely with. And it's so we understand our caseloads as well as what's happening in the system. So all this data is judicial filing data. To set the stage a little bit, and this is the best analogy I can come up with. It's an emergency department mindset in our criminal justice system right now. We are not proactive in many respects, and that's not to disparage any of the actors. We respond to what comes into the emergency department, and then we triage effectively as we can with the resources that we have. That goes for defense counsel with extremely high caseloads, prosecutors, judges who are new inside a particular division, getting their feet wet, understanding, and then 24 funded transport positions. Funding for those 24 has been provided, and moving 600 individuals, the fluid number, right? 600 individuals, 540, whatever it is today, 6,300 pending felonies, right? That's a pretty consistent number we've had for a number of years. So of those 6,000 or so pending felonies, there's a bunch of individuals who are detained. And as Judge Zone said, moving them is a priority. But then as Chair Lalonde had pointed out, there's also individuals who are not being held on felonies who also deserve their day in court. Each of those cases typically have victims. And so we're having these competing needs. Macro, micro, violent versus nonviolent are competing for court time right now. Age of a case versus detention status. More time and space is really what we need. And some of the courts around the state are really being inventive. Windham County is a county that's really working on some interesting ideas, including using their civil courthouse up the road on Route 5 as a spillover jury opportunity during days where we have opportunities for trial. So I just want to put out there, here's the data, right, from May 1. It's on your page. In terms of the backlog, the green on this chart represents, if I can remove this part of the screen. The green on this represents positive movement. It's counties where we've moved more cases from 2023 to 2025 than we filed. That's a good thing. About a 15% reduction in cases pending over a 2-year period. That means the defense bar, prosecutors, and the courts are working very effectively. Just in 3 counties, and they're not large numbers, was there a slight increase. But in overall, right, we moved about 3,600 cases in the better part of 2 years. That's a very good thing. We need to make more progress. It needs to be more like 150% as opposed to 108. I did attend a wonderful conference with Judge Zone and a member of Defender General Valerio's staff in Maine about what other states are doing to move court backlogs. And many other states are dealing with these similar issues. This is just year over year. You can see we slowed down last year a little bit. This is just a 1-year picture. Just we moved 560 cases in about a 1-year time period. And then that's all cases. That includes family court cases that we cover, and includes the civil court cases that we cover. And looking at the homicides, and Matt will be the first to point out, these include the entire spectrum of a homicide filing: accessory, attempt, conspiracy. And so these numbers, you can see most of the filings are the last 3 to 4 years. We've had 20 or 22, I think, homicide victims on average the last 5 years. Prior to that, it was something like 9, 10, or 11. So we've had this uptick that is in large part due to the drug marketplace in Vermont, our very ready availability of firearms in exchange for drugs coming into the state. Right, when you have drugs and firearms in these situations, it's a very toxic cocktail. As of May 1, there was 117. We did a more recent poll just on the homicides, and it was more like 130 as of a couple of weeks ago. So 130 or so pending homicide-related cases. Not all of those are completed homicides. If you look at the arrest warrants, which I think is an area that you were getting to, Chair Lalonde, we just took a 10-year time period looking at some of the arrest warrant data. There was about 4,400 pending arrest warrants from 2015 to 2025 as of May 1. These are things that are unresolved. Sometimes these people, I'm going to be right up there. Some of these people on this list are dead. We just haven't dismissed the case yet because we haven't gotten to it because we're too busy dealing with stuff spilling over the edge of the ship in terms of what's coming at us. People with multiple pending dockets. This is one of the main drivers. In addition to violent crime taking up most of the time in our courtrooms, we also have people with multiple dockets. Usually these folks, if they're picking up multiple dockets, a lot of these folks are not detained, but they're taking up a lot of court time. They show up to court, they contact the Defender General's office or get in touch with them on the day of arraignment, but they're coming back and coming back. Some of these folks, as we know, have mental health issues co-occurring, so it makes it very difficult to resolve because of the fluidity of competency. You are presumed competent every time. And so you have to go through that competency process every time. And if Senator Lyons were here, she would, this is an issue I know we're working on with her. But we had, as of May 1, 44.2% of all dockets were for people with 3 or more pending dockets. So about 50% of the cases that we're dealing with are individuals with 3 or more pending dockets. And that means that we're taking up a lot of time on the violent cases and then on the people with 3 or more. As you can see, 5 or more was 25%. So 5 or more is a quarter of our cases. So that number 5 or more comes up a lot. Judge Zone has been sending those lists to his court staff. It's a really important thing to think about. A group of people, relatively small number, taking up a large amount of the number of pending cases. We had 11,000 individuals with just 1 pending docket. That's still the majority of cases, but it's maybe not the majority of the time that we're spending. The mental health dockets are really interesting, a very small percentage actually in terms of cases overall, but they take up a huge amount of time. And when they are related to repeat offenders or people with repeated arrests that come before the court, they push other things off of that docket. And we do some mental health proceedings in the criminal division. And it's important to note that in our department, sorry, I keep looking at Deputy Plunkett, Senator Plunkett, but in our department, we do a lot of that work in Title 13. As Matt Valerio knows, Defender General, there is more of a team approach, which can sometimes complicate things. Legal aid, Defender General's office, and DMH all in the room with us. The cases are very difficult to resolve, even if it's a misdemeanor case. When it's a felony case, also very difficult, but mental health doesn't care, misdemeanor or felony. And that is something that the community is crying out for. This is a snapshot of our top 20 prosecutors with the highest caseloads. I removed all of their names on the left there, but we had prosecutors in the 600s, the 500s, and you'll see on the left the pending felonies attached to those prosecutors. We had a prosecutor with 193 pending felonies attached to them. The national best practices, you shouldn't handle more than 150 felonies in a year. You shouldn't handle more than 200 misdemeanors in a year. So when this is our snapshot, we know that we are handling more than the recommended numbers. And Northeastern University put out a study for prosecutors about how many they're handling and they should handle. And it's about the defendant's rights, right? Prosecutors shouldn't be handling this many cases because it's not good for the accused to have a prosecutor overburdened, overworked, who really should be approaching these cases with more time. And if we had more time and more space with each individual case, and that's one of the main reasons to drive down caseloads, defendants, in our opinion, would have a more catered approach to each one of their cases. And victims would be getting more particularized justice in terms of the time afforded to their pending cases relating to them. Of the 72 attorneys that we had at the time of the poll, the top 20 prosecutors had an average of 456 cases. The overall, collectively, 72 attorneys in our department had what I would describe as unhealthy high numbers of pending cases. I think we're trying to get at the prosecutors that are handling lots and lots of cases. Sometimes they'll be handling the low level stuff, right, with victims attached, and then they'll be handling a homicide the next day. I know that's true for the folks in Matt's shop as well in terms of when cases come in. That's very interesting because in a lot of other states where they have larger departments, more resources to do things, you have an arraignment attorney, you have a misdemeanor attorney, you have a felony attorney, you have an appellate attorney. We're kind of all just one thing here in Vermont for the most part in terms of our department. And that is sometimes hard for victims of crime to actually comprehend. Oh, you're dealing with a DUI one and this triple homicide. That feels like maybe not a good effective use of our time as individual prosecutors. Here's that study from it was Northwestern. I might have said Northeastern, but maybe it was Northwestern. Trials. We've had a lot more trials over the last 3 years coming out of COVID. From 2023 to 2024, we increased trial date utilization by 65%. That's very, very good. We've increased it even more over the last year. You'll see Windham County is #1 with 39 trial days used. Those are days where you're not doing other things, by the way. You're not doing status conferences, you're not doing resolutions, you're not doing motion hearings, you're just doing trials. And it means that, yes, you're moving those cases, but you're not doing other things. Windham, Rutland, Orleans, Bennington, and Chittenden were the top trial date counties in terms of days used for trial. It's important to note that trial dates are the engine to disposition of cases. With trial dates, people are more likely to have that plea agreement mindset, putting that pressure to the caseload. And we do see lots of resolutions as a trial date looms. If we have more trial dates available, and we're working on that with Judge Zone, and more time in dedicated spaces for the nonviolent cases, we do think we would see more cases move. But it's almost like, what a terrible scenario when we're having the violent felonies competing with someone with 40 retail thefts. It's not fair to anybody. So dedicating time and space to that and being creative about that with existing resources is something we're very interested in. This is our modern art page, right? It shows all the months over the past 2023 to 2025 where we've had over an 100% clearance rate. So we have a lot of that, but we also need to do better. You can zoom in if you like on that. The backlog, right? As Judge Zone said, we've consistently been over 100%, but we do need to keep moving. This is another interesting one by county. The green indicates positive movement. The red and orange, et cetera, are difficult ones up moving in the other direction. The total percent change by county is represented in this column here, and my mouse is on there. You'll see there's some counties, for example, where we're over a 2-year period, Bennington County, 76% reduction in cases. That's very, very healthy, and it allows for more time and space. You still have a lot of cases coming in, and Bennington County is the second highest county in terms of pending filed homicide-related cases. Obviously not proportionate to population, more proportionate to where they're located in the drug distribution highway. That's really some of our big picture takeaways. Obviously, we're always concerned about caseloads. Always concerned about our ability to move cases. And we've run into issues of particularly the last couple of years where in Judge Zone's office and my office are in conversations on this. Doing the priority analysis, when we get a transport order, it's an order from the court, and we treat all of those seriously in terms of the transport program that's under our department. We're not in the business, hopefully, of policing what one should take priority. Each one of those judges issuing that thinks it's a priority. So where we have good contact and communication in an informal way with those courts, do you have the capacity to transport this person, or are you otherwise engaged? Those 24 transport deputies with funding right now are doing statewide work. For example, the 2 Washington County transport deputies are routinely doing work up and down 91, 89, and to Chittenden. The Chittenden folks with the female facility are constantly transporting those folks to other counties. So they aren't just doing work in the counties where they're located. It is a statewide program, and we locate those individuals to be helpful statewide. We do absolutely need more capacity to really comply with orders. We have an uncomfortable status on a regular basis where we moved about 4,000 people last year. We don't have that per diem bench, the pure county bench waiting at home like we used to. So we just have those state employees doing that job. And it means that we are sometimes trying to police, okay, this status conference for a misdemeanor feels less important than this weight of the evidence hearing for a homicide. So then we reach out to the court. Sometimes we are, and we're working with Judge Zone on this, met with a lot of pushback on that. And so that's why we're hoping to work on a plan almost as akin to the attorney conflict scheduling issue. Attorney getting scheduled in 2 courts at once can only be one place at once. The ability to notify the court, tell us what the priority is. We will try to make it work. Even yesterday, we had something, and the Department of Corrections has many policies, including those relating to individuals with hearing deficiency. That individual is a good person to transfer to the person so they can understand what's happening. But that notice came less than 8 hours before the transport needed to happen. We were at full capacity. We're at risk of falling out of compliance with a court order. That's a terrible position for us to be in. And often we are trying to advise the sheriffs and the transport deputies in the field, try to work with that local court about what you're going through. Call the state's attorney, see if they can maybe resolve the case. But it's got to be a combination of video arraignments, in-person arraignments, and really a prioritization system. If we aren't going to have more transport deputies, which obviously we think that we should, it will help us say yes to more things. And really our bread and butter in the Department of State Attorneys and Sheriffs, the transports, is criminal cases. So there's the 3 buckets of potential cases: family court, civil division, and criminal. The criminal cases, we know there are liberty interests at stake. Every single one of those cases where there's a detainee. So that's always been our priority. For the better part of a half century, the Department of Corrections did facilitate in assisting and even leading the facilitation of the persons in civil and family division cases. There are different levels of due process and liberty interest in those divisions, and we do not question that. But our priority has to be the criminal division because that's where we need to prioritize in that mix. So we're working on what that looks like. We do think law enforcement agencies, municipal, state police, constables under statute are allowed to transport people. Everyone needs to be at the table to move as many people as possible to court, not just the 24 state employees moving around the state right now. I see what they go through, and it is an incredibly alarming. Talk about transportation. People do 16, 17-hour days this week because we have murder trials going on. These are the same staff that are moving people in extraditions. So the same group of individuals are going out of state. We had a trial this week that required transportation from 4 different states for a trial up in the Northeast Kingdom, and it required our limited sheriff staff to leave the state, then they're not available for transports in the state. So this is a real crisis with the transportation program, and it's being felt by the state's attorneys, judges, and obviously the defense. They want their clients to come to court. They don't want us policing which one of their clients can come to court. And the people receiving the brunt of it is, the transport staff who are trying to comply with as many orders as possible. But right now, and I know former Sheriff Norris understands the complexity of moving people around. At this point, we're not staffed to move people around with 2 people in the same car. I want to put that on the record so no sheriff needs to. We have a policy where female inmates, people who identify as female from the Chittenden facility, are transported with 2 people. That's the only mandate that we have in terms of people in the car. Other than that, we could not issue a mandate like that.
So besides dealing with the transport, what other levers do you anticipate asking us to pull to help out with this?
Yeah, I think one of the levers has to be, and I don't know if all that's legislative, frankly, but obviously conversations. It's about ensuring that the judiciary and the system in general has the space and time to effectively, let's say we have a judge available to sit in the Washington County Civil Court here, the red building, but we don't have a judicial assistant, making sure that we could have that spillover effect for nonviolent offenses, that capacity. If we reduce our caseloads because of increasing our ability to move those cases, if you set 40 misdemeanor nonviolent cases here in Washington County for trial in the red building here in town using that civil space, potentially all of them will resolve. But setting the date is going to be really important. So creating the space by all means necessary to give the system the ability to use every possible space to move cases is going to be important. I think it's a resource, potentially staff. If there's any rule changes that we need to work on, it's got to be everything, not just statutory. So we're at the table with that. We're talking to folks only about that. And it's a scheduling issue too, with, ensuring that we have staff. Another one is the sentencing options, ensuring that we have, whether it's the work crew of the past or the work crew of the future, a binary sentencing option where compliance is a binary conclusion. Did they comply? Yes. They satisfied. Did they not comply? No. Then they are incarcerated. That's the way that the sentence used to work. I found it to be very helpful here in Washington County. Many others did. So I don't know if it's the work crew of the past, but something where it's the binary sentencing option. We need something like that back on the table. Another thing we need to ensure is that DOC has the tools to do video arraignments for all different types of people, so that we aren't bringing in someone that could resolve and walk out in Chittenden down to Wyndham or Bennington, strip searched, 8-hour trip, food, all the different issues, when we should be transporting our major felony cases in the cars. So we have to keep a focus on prioritizing, putting a priority on the types of cases that need transportation. And I don't think we're going to get 100 transport deputies. I totally understand that, right? You're in a very difficult budget year. But if we're not going to do that, we need to figure out a system of what comes first. The other thing I'll mention, obviously, is the digital environment that we're living in right now means even really basic cases have a huge amount of evidence. A basic DUI case could be 30 hours of body camera footage. Right now, we're having attorneys spend time doing that. So administrative professionals, paralegals, would be a really helpful thing for our department. And we'll obviously talk about resources down the line. You know, Representative Squirrel is our budget representative on appropriations, and that's something that we'll have to talk about. The victim advocates have 600 cases. They're a real engine to moving cases because they're talking with the victim. They can tell us, how is that case going? How's the victim feeling about it? Right now, they have 600 cases per person. They're not able to spend enough time with each case to advise the attorneys what's happening with the case and maybe how the case could be resolved. Victim advocates definitely help drive resolution. Right now, they have too many cases. So those are some resource pieces. There's a sentencing piece. There's a judicial efficiency piece that we need to talk about.
So we have a question from someone who's on Zoom. You can't see their picture. Nodder, I heard you had your
Thank you.
hand.
Hey, Tim. Quick question, and this also might be a question for Judge Zone, but what I'm curious about is the trial grid itself. And, you know, one thing that's perplexed me a lot is why, you know, the cases that don't get drawn end up getting reset for another pretrial conference a couple months down the road, only to be put back onto the jury draw the following month after that pretrial conference. Has it ever been discussed, or has the idea ever been raised that cases which, you know, are lower on the list but don't draw still stay on the trial grid for the next jury draw?
I would let the Chief Superior Court Judge answer that.
If I understand your question correctly, yes. But the reality is that the opportunity of the parties to get together for the pretrial the next month, as opposed to just going on the draw list, allows the flexibility for any changed circumstances. There's new dates for trial. And those are the things that are being discussed at the pretrial. And so just putting it on the trial list, there's no discussion of available trial dates, witness availability, and those are the types of factors that change. Plus the idea that the parties might, that next time, be able to navigate the gap and resolve the case that they otherwise could have resolved a month earlier.
Thank you.
Have questions, Mark?
Yeah, so I'm looking back at the people with multiple dockets, the cases. And by my count, 205 people, at least on May 1st, account for 18% of the dockets. And you were looking at the 5 or above, I'm looking at 205 people. So my question is, do you know how many of those individuals have competency evaluations? How many are found incompetent to stand trial? And how many then are cycled back in to the system? I mean, how big of an issue? I mean, I hear it's an issue, but I have no concept of how it's an issue or not.
Yeah, and actually, another thing to note is there's both the finding of competency and then there's the litigation of that finding. A lot of times, just the litigation. So we find you incompetent, and the other side may get an expert to reflect that, and then you have a hearing about that. So the litigation of that is pretty high. So we have a lot of folks have many cases where that's happening in a lot of the repeat categories. For the people who are actually found incompetent and then it's not challenged and it's just sitting there for a period of time, that number, right, is sometimes then litigated further as to whether or not the case should be dismissed. If the person picks up more cases and the presumption of competency restarts, that's where we're having the issue. So with the repeat offender population, we're seeing that competency isn't just an issue as to whether or not they are, it's litigating that process itself, which is taking up a lot of time. I will say, because of the way that things are right now, for the nonviolent cases, our prosecutors are, we do not have unlimited resources. And so our expert witness funds are pretty much set aside for felonies. And I think that is very disappointing for victims of crime where they've had the same person come through their shop a number of times and they keep being found incompetent. We honestly, the state of Vermont does not have the money to litigate competency in many cases. And so it is a major problem for the repeat offenders, but sometimes we don't challenge it. It doesn't mean that we actually believe that we could not prevail. It's because we do not have the resources to challenge the issue. And we reserve those resources for the most serious violent cases.
So how much does the state's attorney think if one of these individuals found to be incompetent, determined not to challenge it, or you challenge it and they're still found not to be competent, what does the state's attorney do afterwards? Do they file a civil motion for non-hospitalization, or what's the follow-up so that this individual does not cycle back through again? Or isn't there? Or is it not the Department of State?
I would need a couple hours to really dissect that question. And I'm not going to do that to you. What I will say is that many of those individuals end up on ONH's orders of non-hospitalization. Often they expire pretty quickly. And then the only reason we find out about them again is when they commit they are arrested for a new crime. They're not. So that's how the system's currently working. If they're not competent, we cannot proceed with the trial. We cannot proceed. So then they might be on an ONH. Maybe it's a stipulated ONH. Maybe it's one that the judge had to order it. But regardless, a lot of people end up on orders of non-hospitalization. And then they sit out there. Sometimes there's actually differences of opinion between legal aid, defense counsel, the state's attorney, and DMH. And in those cases, man, I really feel bad for the judges because there's multiple state actors in the room who do not agree about what to do. But right now it's a complete mess for those cases, frankly, in terms of people with multiple cases who come back, and we only interact with them again when they come back. And the state's attorney can choose to dismiss. Sometimes Vermont Legal Aid will file a motion to dismiss in the interest of justice in some of those cases, and then we litigate that. But sometimes we keep them open, and particularly they are kept open when someone picks up a violent offense in addition to those other ones that are kind of hanging on to the violent offense, which is the lead case. But it's a huge amount of time that we do spend on these. And we have a few experts in the department on this issue that could come in and brief you in more granular level. Yep.
The questions before we move on to the Defender General? Thank you, Tim.
Thank you. How do I stop sharing?
Matt, why don't you come on up? Matt?
Oh, thanks for having me. Usually I do this right, so, if you end up with my schedule here. All right. Can I get back here? Yeah. Okay, good. Not so bad. All right. So I was initially told that I'm Matt Valeria, by the way, Defender General. I know all of you, but for the record, I was told to talk about the backlog, and I have what I think is very good news in the short term and horrible news coming. So I'm just going to give you the bad weather report, right? And there are a number of factors that are impacting this. You'll see, this is all from court data, right? The real important thing is the kind of the bottom of the lines, and this goes from 24 until 25, and I was updating that as of this morning because we got the 10-1 data, right? So if you look across the bottom, in June of 24, we had 14,000 pending cases that were considered part of the backlog because they weren't fitting within the time guidelines. And those sort of went up and down a little bit, dropped to 13, go back to 14. We stayed at 14 for a while. And even as of September of 25, we were still kind of hanging in at the 13,488 number. But the October numbers, as of the 1st of October, saw 3,000 case drop in the backlog. And that's the really, really good news, that finally the judiciary has enough judges on the bench to impact the backlog. And that's what I think is the biggest driver of all of this. You know, part of it is too, it's not just the number of judges, but there were a bunch that were new all at once. They're still getting their feet wet. They're trying to see what they could do and what they needed to do. Everybody's different as far as their capacity. There were some judges who really did have a handle on how to get the caseload moving, and they did. And you can see this big change. Now, I fully anticipate that it's not going to stay exactly like that, because if you look at the trend over a period of time, which is this, we've kind of been floating around between 14, 14,203 and 13,000 more or less. But if you can see that, basically that last month took a big dip. I don't know if that is going to be an anomaly or whatever as this works out. But at least in the short term, you can see significant progress. 3,000 cases is a lot of cases to get rid of during that period of time. All right, so much for the good news.
Were they the easy cases that they got rid of?
I don't know. I mean, easy, hard, I've seen DUIs, which are some of the hardest cases you could ever imagine. And I've seen murder cases that are really easy. It's very hard to say what that means. If it's low-hanging fruit, then so be it. We'll take that too. Because before we weren't getting at the low-hanging fruit. And in fact, for a period of months, if you could see the end of that dip up until September, we were actually starting to climb again, right? But huge dip there. Here's where you're going to have a problem, and I'm forecasting a nor'easter for the next 6 months. Lots of snow and ice and lightning and terrible stuff. In the public defense system, for the first quarter of fiscal year 2026, I highlighted a couple of things. Felony cases are up almost 8%. Misdemeanor cases, and for us, cases are people, right? Cases aren't charges, right? So new people in the system up basically 8%. New misdemeanors up 14%. Other is basically probation violations. Those are up 30%. And if you look, and this is what really is that the highest growth of all is in Chittenden County. Did a 37% increase in the first quarter of new people with charges in Chittenden County. There are other counties that are, way up. Addison more, over 100%, but it's a small county. But we have other counties at 15%, 18%. But Chittenden County represents 39% of the total state caseload in public defense, and they went up 37% in a quarter. Overall, the state cases, that is cases meaning people in the system, went up 15.3% in this quarter. None of these people are in the backlog, not one of them, because they're too new, right? And charges are just like the number of counts, right? When I was looking at Tim's charts about counts and people, I'm not so concerned about the people with like 5 counts or less. those don't bother me because many of the information's charging documents that you see 4 or 5 counts with every charge. And I don't know how you,
Those are dockets.
so you're talking about people? So new incidents.
Yeah, not charges.
If I could ask a question, just
Yeah.
on what the numbers are. So the first chart that you showed us, not this one, that was cases that are older than a year.
Those are cases that are
Okay.
qualify as backlog.
Okay. And by cases, you mean a defendant that has dockets in the system right now.
That's actually from court data, not my data. This is my data. This right here, this is court data.
Okay, so this would be docket numbers.
Is that docket numbers? Okay.
Doesn't,
You know, the interesting thing is some state's attorneys do this differently. So they'll charge a docket and then there'll be 5 counts under the docket. Other state's attorneys, they'll charge it and then you'll have a docket number, but each charge will have a separate docket. It's hard to compare apples to apples. Just everybody traditionally has a different way of doing it. And it's not that far off, but I mean, it tells you a story. It just doesn't tell you the whole story. I was more concerned about like the top 3 there where you've got 10 or more and the people who have 20 and that, you know, because no matter how many, you know, you're not getting a case that comes in and they are charging 20 dockets of, you know, violation of conditions of release or whatever, unless it's Essex County. So, hi Vince, I think you're doing well. In any event,
Before you move on, Matt, real quick, just to clarify, the definition of backlog is those are cases that are over the criteria, the disposition standards. So for misdemeanor, it's 180 days for your standard misdemeanor, 365 days for.
it's not all of them are a year.
It's not a year, it's anything over the.
right, yeah, they're different for misdemeanors, different for felonies. You know, we actually have this reported to us soon after the first of the month by the court every year. And I've been tracking this, you know, I can go back to COVID. If you ever want to see that chart, that's very interesting. But I don't know that it's, the thing that's interesting about it is that caseload was really low, but we weren't doing anything. So like the backlog at one point was almost 19,000. So from 19,000 to 10,000, we're down 9,000 from like its highest point. But we've been lingering around this 14,000 range for a while. And that's, you know, the last couple of years. And this is, I just charted it out so you could visually see what was happening. This total added criminal cases for us, I'm not worried about the charges. I'm worried about the cases, which is the people. And overall, you see a 15% increase. Now, the interesting thing about this is over the last couple of years, the public defense system as a whole has seen a shrinkage in the number of lawyers who are available to do the work. 2 summers ago, we lost about 5% of our contractors. And this past summer, we lost about 15%. So we now have 20% less contractors in the field doing the work than we had 2 years ago. Chittenden County, for example, used to have 2 years ago had 5 conflict public defenders on the first level to get assigned cases that were conflicts with the staff office. They also had 2 contractors behind those 5 to take conflicts that went through those 5 people. And then we also had 3 caseload relief contractors behind them to absorb. They didn't do just Chittenden County, but they absorbed conflicts from a number of counties in the north, trying to be in the north anyway. Right now, we have 4 primary conflict contractors, and that's it. We have 1 caseload relief contractor, and then we have 1 that is splitting time basically between the entire northern part of the state. basically Northeast Kingdom all the way over to Chittenden and Franklin, and dips down into Washington County. So we've lost like 5 lawyers up there that used to be doing work, and they've retired. They've left the state. They became ill and could no longer work. And we don't have new lawyers to replace them. That's fundamentally the deal. So what ends up happening is the 4 who are there get paid a lot more money to handle the caseload, but this doesn't help the backlog. And this is why I'm predicting this coming nor'easter, which is while they are there assigned to the cases to do them, one lawyer can only do so much as far as moving cases. And when you're down 5, you got a problem. That's just Chittenden County. I could talk about all the other counties if you want. But the bottom line is statewide, we're down 15% in the number of lawyers who are available to do the work. And this isn't about the murder cases or the like. This is about like the bread and butter type cases. And while we had, we averaged 11, 12 murders a year for, 30 something years. And like, if you do the average in Vermont, it still is telling us it's like 13, 14. But the last couple of years have been high. Where we have, 20, 22, 23, that's not the highest we've ever had. Highest, I think, was in 1992. And I think we had 32. But the very next year, it dropped to 4. So, we had this kind of anomaly in 92. What we're seeing now is a more consistent change in like the very most serious cases that we're seeing. Now, I'm going to show you a little bit more. On the juvenile side, we also saw a 23% increase in cases overall statewide. And lo and behold, Chittenden County saw more than 100% increase in juvenile cases during this first quarter of fiscal year 26. Washington County was also remarkable, and also Windsor County was higher, but it was smaller, much smaller numbers. But Chittenden County is a hotbed of legal activity in the public defense system. And given that it's the largest county in the state, again, representing 39% of the total caseload of the public defense system, that's a problem. And it's also a problem where we lost lawyers. I also know in that same county that while we have people who have agreed to hang on and keep their contracts and continue to do the work, they're old. They're all old. We don't have new people there. We have people in their 70s and late 60s who are still doing this work. And they've told me they got a year or 2 left before something changes. And so that's where we're at. Gave you a summary of the first quarter criminal with each county. And these, the increases that I showed on the big chart. The felony caseload is similar. Like bottom line is we've seen increases in felonies with every county. Now, if you look at Orange is a 0 because the person who did the stats for that primary that's contract office was not able to do them. They were out for the quarter. So we'll get them at some point. I don't have that data, but if you look at the rest of the state, it seems like the felony caseload across the board felony caseload is up over 20%. This is just a graphic way of showing what has gone on from 23 to 25. This is important because it's not just this year. The increase in 23 was like 7%. The increase in 24 was a little bit like 7.5%. And now we're talking about 15%. So you're talking about like 30% overall increases over the last few years in the public defense added criminal cases. There's no wonder that prosecutors are drowning and that the system is stressed. All at a time during some of this time when the court was down 5, 6 judges and we aren't adding new lawyers. And so the system is consolidating and the people who are hanging in there are making more money, but they're killing themselves. And it's not healthy for anybody and it's not good for the system in any way. This is what I was just talking about. You have these increases in criminal cases, 7.2%, 23 over 22, 7.4%, 24 over 23, and now for the first quarter of 25, 8.6%. And so what I'm telling you is we've done some good work with the backlog. We are not even close to out of the woods. You've got a problem that's coming, and it is much more fundamental than whether we get transports. You know, transports are part of it. You know, everything's part of it. But it is, you know, I've tracked these things too in like election years. When state's attorneys get elected, what happens with caseload, and over time, you do see sometimes that in election, I know, you know, nobody would ever agree, but you do see little increases, you know, increases. You don't see increases like this. This is remarkable. I'm actually hoping, you know, something will happen. It's one of those things where, you know, hope is not a plan. I hope next quarter we'll see some mitigation of this. But like I said, hope is not a plan.
So what's the plan then?
Well, you know, one of the things I've been doing is trying to recruit lawyers out of state. You know, I brought people in. I was also down this year in the staff system. Forget about the contractors, which are a major problem. But I was down 7 lawyers in the western part of the state for 6, 8 months. I wasn't even getting applications. And I couldn't get, you know, nobody was, you know, we don't get any lawyers from Vermont Law School. So I don't even basically bother at this point. But I went out of state. I went to Tennessee, went to Kansas, went to Florida, you know, North Carolina, Virginia, New Jersey, and the public defense system in New Hampshire is kind of imploding right now. And we were able to hire 3 people out of there. And Prisoners' Rights Office was down to like 1 lawyer, and they're supposed to have 4. They were down to 1 lawyer for like 18 months. People left because nobody was applying for those jobs. And so I had to go out of state. You know, the usual places you might think, trying to bring in lawyers from, you know, Massachusetts, go to Northeastern, have an actual public defense program to breed public defense lawyers. You know, some of the Suffolk, Western New England, some of the ones that we weren't getting them because we can't even come close to paying what the private sector is paying. We're so far out of whack from a pay standpoint. What you have to do is get people who are working in public defense in other states who want to work in public defense to come to Vermont, because as difficult as it is here, it's not as bad as it is in Tennessee. It's not as bad as it is in Florida or the other places I'm talking about, or apparently New Hampshire, because they're running over here. So, you know, that's part of the plan, is to increase recruitment in non-traditional places. I have a little bit of a pipeline to Alaska. I've had a couple of people I've hired out of there over the few years, less lately. But, you know, the unfortunate thing is I hired the guy I hired from Tennessee. He stayed with us 6 months and then he went into private practice. He left. I can't keep him. I know the state's attorneys have the same problem. They can't hire and they can't keep them. It's really at the core of what's going on with some of this stuff. We also have, of course, the issues with the crime itself. So my prediction is that this backlog, we've seen some good progress. This is not sustainable right now. And you can just see it in those numbers. Now, if things calm down a little bit for a couple of quarters, you might start to get some traction again, but that's not, at least I hope it's not a plan, right? There were various things that people said along the way that I'd be happy to comment on, but I think that what I came here to say, I said, so.
Thank you for the good news and thank you for the bad news. Any
Probably something to talk about.
questions? Matt, this won't be the last time that we talk about this, I'm sure. We'll have more, once the session starts in January, there'll be more updated data.
Yes.
I want to get out of here so that I don't walk down the hall with my music blaring in here. Can you just throw me off of the meeting or something? That'd be good.
She can throw anybody off.
Then I don't have to go get back into it and figure out what to do. All right, thank you.
Thank you.
And by the way, if you have any questions after the fact, something that I didn't touch on or we don't have time to, just give me a call and I'm happy to talk to any of you at any time.
Thank you, Matt.
Thank you.
So, we're running a little late, but let's keep plugging on. We're gonna shift gears and go to pre-charge diversion. Ben, do you want to give us a quick?
Because I can.
This is not pre-charge supervision, don't worry about it, folks. It's something else, it's a pre-charge diversion. And this is Martin's bailiwick, right? So Ben, welcome.
Hi, good afternoon. Ben Novogratski from the Office of Legislative Counsel. I will be doing a brief overview of the pre-charge diversion program. This came out of Act 180 of 2024. And essentially it creates a pre-charge diversion program for both juvenile and adult offenders, and also streamlines the statuses for the diversion programs already in operation, which are now referred to as post-charge diversion. And for those of you who aren't familiar with the concept of diversion, what is now called post-charge diversion is this concept where someone is charged with a crime, and then they appear in front of the judge, and then the diversion program is offered to them. It's a voluntary contract-based program that diverts them out of the criminal justice system as long as they meet certain rehabilitative and restorative requirements that they have to take responsibility for the underlying offense. Responsibility does not equal guilt. It is a separate concept, but that is the general concept of diversion as a whole. What pre-charge diversion does is essentially do away with the charge requirement of the post-charge diversion program. It essentially, means a referral, and this is defined in the statute, of an individual to a community-based restorative justice provider by a law enforcement officer or prosecutor after the referring officer or prosecutor has determined that probable cause exists that the individual has committed a criminal offense, and before the individual is criminally charged with the offense, or before a petition is filed in family court for the offense. So those are the two versions of diversion, and pre-charge diversion is the one that we'll be focusing on today. Any initial questions about the concept of the program? Okay, so getting into the details, really the program is designed, and this is a statutory proclamation essentially, to provide a restorative option for persons alleged to have caused harm in violation of a criminal statute or have been charged with violating a criminal statute, as well as for victims, as well, or those acting on a victim's behalf who have been allegedly harmed by the responsible party. And what the nitty gritty of this bill and program does is that, like I said, it codifies this new pre-charge program. And pre-charge is now administered by the Attorney General's office. like it had managed the post-charge diversion program. It also shifted grant authority from the Department of Corrections to the Attorney General's office to support pre-charge diversion providers. A prerequisite to receive that funding is that each county state's attorney must adopt a pre-charge diversion policy. Those policies state that the state's attorneys retain prosecutorial discretion over the people and crimes that are contained in the policy. So essentially, each county can pick and choose which crimes and which offenders are eligible for participation in the pre-charge diversion program. The program also shores up the rights and responsibilities of participants and victims. It mandated that a manual be created by the Attorney General's office so it can be used by providers and others. Participants are offered a public defender at no cost, and victims are notified of their role in the diversion process and their rights to certain information about the participants' journey through diversion, for lack of a better term. For those that successfully complete pre-charge diversion, their records are subject to deletion, which is akin to expungement in this context. So essentially as if the incident never occurred. It also codified data collection from providers to be reported annually, I believe, in January of each year by the Attorney General's office in consultation with other agencies and their partners to essentially profile the program from the past year. Number of referrals, successful completions, failures, things of that nature. The AGO is also responsible for collaborating with the providers and state's attorneys to develop plans to streamline the administration and provision of those programs. The legislative intent behind this, or at least as it was discussed, was to explore stabilizing funding of these programs. And then one thing that's important to note is that this does not affect community referrals. So ones that might, for instance, involve maybe an altercation at school that doesn't necessarily rise to evidence of criminality or probable cause, but is sufficiently disruptive enough to warrant some sort of resolution that is structured by a restorative provider or things of that nature. So that is a very brief overview of the program, if there are any questions.
Doesn't look it.
For now.
So we just need an update in terms of how it's working and the funding, and Willa, I think of this here.
Good afternoon. I'm Willa Farrell. I work in the Attorney General's office with Court Diversion and Pretrial Services programs statewide. Thank you for the opportunity to come and talk about pre-charge diversion. I appreciate Ben's overview, so I was going to start with doing a brief description of what pre-charge is. I just want to note that there's very little difference in terms of probably the response of what the program will be. It's the fact in pre-charge diversion, there's no charge. And typically those cases would be coming to a local provider from law enforcement. Not necessarily, but that will really depend on each county state's attorney policy, how they want that handled. A quick note about history. Historically, there has been a robust pre-charge set of services in some counties, most notably in Chittenden County. And there has been funding from both Department of Corrections and also the Department for Children and Families to do this work in grants, but in broad terms. It has not been as specified, in part because there has not been a statute that has outlined and defined what pre-charge is. The few things I wanted to note about the legislation, which actually went into effect this July, this of that act that Ben referenced, is both the clarity about what pre-charge is. I think that makes it easier for us as a funder. A strong piece in the new legislation is the focus on victims. There's really a lot of explicit language about the rights of victims and our responsibilities as funder, or as for providers, as to what the work should look like relative to victims of crime. Data reporting is something that our office has tried to do well, and that is a little more robust in the law too. I want to thank the legislature for funding this program and also for including a position for our office. And Kelly Ahrens is here with me today. She's in front row. Kelly is on day 9 of her job, but she has hit the ground running. Kelly has worked at community justice centers in 3 counties, most recently in Chittenden County, where she was there for 10 years, working primarily there with her youth team of 5 people. So I think her direct experience and her supervisory experience is really filling a gap in our office in terms of helping to really promote quality and consistency around the state. So it's been a really busy few weeks helping to onboard somebody, but Kelly has already started to do work that has shown me, and I think we'll be able to demonstrate to you in the coming year a real burgeoning of these services. As I mentioned, we did receive funding. So in May, when end of May, when the governor signed the budget, it was like, okay, we can do this. And it was difficult. We, as you probably recall, asked for more funding than we received. And there was a number of other factors changing in the state that made our decision, we wanted to take into account. So the Department of Corrections made changes for this fiscal year as to which organizations and how they would disperse funding. And while they're separate, many of our grantees that are funded by our office, Department of Corrections and Department for Children and Families, are the same. So sometimes there are staff positions staff members who have a job that is funded by multiple funding streams. So there's a lot of jigsaw pieces for providers that they were considering, and they were sending me information about what they saw as their funding need in order to do pre-charge diversion. We also looked at data from the Department of Corrections regarding pre-charge referrals to date. And one of our goals in funding decisions was to ensure that we funded adequately. And that word adequate I use intentionally. It's sort of like what is needed to make this work well. And it's constrained enough because we're trying to spread that funding as far as possible. So to cut to the chase, we did not fund in every county. It was a difficult decision, and it is hard for those counties' stakeholders not to have that funding. We did not fund Orleans or Rutland County. Those counties and those decisions were based on existing data provided by the Department of Corrections and also information I received from providers around readiness and their staffing configuration, not just those counties, but other counties, as they say in this jigsaw puzzle. I do want to give an update regarding Orleans County. That organization had some recent staff departure, which has allowed them, in combination with some funds, they have client fee revenue that has built up such that they are able to have for the remainder of this year, 10 hours of a staff person work on pre-charge diversion. The other piece I want to note about pre-charge funding is those 2 organizations also that we did not fund in Orleans and Rutland also receive money from the Department for Children and Families, what is called the BARGE grant. That allows those organizations to work with youth who are referred pre-charge. So there is that capacity. The other change, which was in our office, in our grants, we said to those 2 providers, we're not giving you an increased allocation for pre-charge diversion, but if you have capacity to take any pre-charge cases with your funding that we gave a 3% increase based on the budget increase, you may do that. Historically, sometimes a director will call me up and say, I got this case, but it wasn't charged. We really want to work. Can we take it? And I said, if you've got funding, municipal funding or something, yes, but you can't use our state dollars to do that, given the way at that point, the statute was written. So there is being some flexibility that allows for creativity in those counties. And those providers are involved in the program development work that we are doing, which is really a lot of what this year, FY26, is about. Regarding next year, FY 2027, we're in our office, as with, around state government, working on a budget. So we will be coming with that information later. My goal is that we will be able to provide funding statewide. I think it's a realistic goal. What that actually will look like is what we're working on now. Regarding program development, so the actual, what is this program going to look like? I'm using this analogy. I'm welcome for feedback if it's too hokey, but there's the, common expression that we're building the airplane. We're flying the airplane while we're building it. So we are doing that, but at the same time, we're also joining up with a few other airplanes that are in the sky. And that's, it's complicated, but it allows for learning and building on experience, and also and maybe even add in one of those airplanes is post-charge diversion. So we're trying to align with current practices and also really hew closely to the restorative justice principles that underpin post-charge diversion. We have a committee, a pre-charge committee, that has providers from 5 counties. Some of them are brand new to pre-charge. Some have been doing pre-charge for years. It's been a good mixing pot of experience and ideas and innovation. We started in sort of maybe classic bureaucratic fashion of looking at forms that law enforcement would use. And I appreciate your laughter, Representative Evans, and it's been really a good way to talk about, well, what is this program? What does it look like? How will it function? What is useful for an officer in the field? How will the records person in that agency actually send it? And we've had some very helpful feedback from the Center for Crime Victim Services, law enforcement, both state police, sheriffs, municipal officers, and also the Vermont Disability Rights. We've been really trying to make sure that information given is in clear, plain language, and that could be understood by people. We're looking at data collection and how to expand what we're doing. Historically, in the report we submit annually, we've reported data by county. For pre-charge, we're going to also do it by law enforcement agency. And so that will go back out to different departments and to each state's attorney so they can see those data. A piece that Kelly will really be focusing on is this manual. We have an existing manual we're building off of, but as I mentioned earlier, there's a lot more robust work we need to do about notification to victims and how we share information with victims. And all of that is done in partnership. So the AG's office we don't just issue something, we develop it with the partners, and we also get input and feedback from victim advocates and our other stakeholder partners, including the state's attorneys and the defense bar. That's all the statewide level. And then, as you can imagine, locally, there's similar conversations and discussions happening with each individual state's attorney regarding their policy, how local different police agencies in a county want to roll out, which they may be rolling out, or maybe this is, explaining how we maybe switch to a new form. So there's multiple efforts at the statewide, local level, and then within each region, a lot of discussion about process to ensure that we're building, as the statute talks about, a consistent system statewide. So that's our end in terms of once we receive referrals, how are we working with people, those who are responsible for what they did and also those who are harmed. So that's an update.
It just seems like you've really, in the transition, has started to settle in.
Yeah.
For the last year, it was really unsure how we're gonna move forward. And the funding did come through, it's a little less. But we were just really trying to clarify the funding stream because it was really complicated with dollars coming through DS.
So, yeah, I don't really have a question, but I'd like to just kind of ground the testimony that we've had as far as why are we doing this? And the concept is that we're going to have, if you send a case into the pre-charge program, you're going to have quicker consequences, quicker accountability. I mean, it's a lot faster than if it goes into the court system. And we know and been hearing from so many people the last few years that having the consequences and accountability close to what the behavior was is helpful for deterrence. Now this, it's for the right kind of cases, not all kind of cases should be going there. So there's that, I think, is really, really important to make sure we understand. And it's also better outcomes for not only the offender, the alleged offender, but probably more importantly, often for the victim. So these are really two important things. But a third, and kind of why I'm happy that we're having this today, is that it diverts cases from the criminal justice system. Before, depending on what the county wants, what the state attorney wants, the state's attorney doesn't have to see them at all, or doesn't have to spend any time if the law enforcement is directly sending it. So there's all these benefits that I think we need to just be clear of why we're investing time and money in this effort. Is anything wrong there?
No, I appreciate, I feel like I just sort of dove in, Representative Lilloan, without naming like, why is this a good program? And it really, I think the first time I testified in House Judiciary about this bill, I talked about why I had originally been skeptical about pre-charge. But the thing that really convinced me is the rapidity of response. And I have heard repeatedly, and I think you have Becky Penberthy speaking later. And when I first met Becky, she was only working in post-charge diversion in Lamoille County. And then when she has since moved to Burlington, and hearing her talk about her experience of pre-charge diversion. So it's always fascinating when you hear people add on to their experience. That is the most compelling piece, is that it's a very fast response. You can have a program reaching out to somebody who did something the next day and to the victim the next day. And for all of us, immediate, we want, and even if it's all that is being kept informed, is so important for people who've been a victim of a crime. And then the effectiveness of the restorative response, community-based, really focusing in on what was done and why and how to make amends. It's comparable to what happens in post-charge diversion, but that may be many months after, by the time the case actually gets through state's attorney's backlog, prosecutor's caseload, and then referred to diversion. So.
Maybe a quick question. When do we anticipate starting to see the data, which was an important part of doing this program as well? Are we going to have it from this first year?
We collect data quarterly. So I'm hoping that in January I could give you some, it would be very basic data. And I mean, happy to share with you what we have for 2 quarters at the start, probably end of January to be realistic. Oh, yes, right. Yeah. And my only caveat about that is some places have yet to hire, like who are recruiting. Some people have hired, but they've got 4 referrals so far because they're still going out and meeting with their local police agencies. So I have said to people, like, this is a year of transition. This is a year to build and develop. And yes, we want to share data, but don't worry too much about numbers. So I hope I'm right in saying that to people, not to worry too much about numbers. And in certain counties like Chittenden and Wyndham, Caledonia, for example, they have ongoing robust pre-charge programs. And so you will see significant numbers there.
Right, thank you.
Okay.
What types of data are you collecting?
So we collect what the charge would have been. Then we collect demographic data, age, race, gender, language spoken at home, housing. We have like what we call housing status, which is really self-identified, whether somebody feels they have stable housing or not. Then we document amount of restitution collected, whether the case was successful or not. Successful meaning that the person completed all of the elements on their agreement, restorative agreement. Those are the highlights. Kelly and I are meeting with folks from the Office of Racial Equity. I think it's next week, who was one of the partners named in the statute. So we'll also be looking with them about our data. And the other sort of data help I've turned to is Crime Research Group. So that's the meeting. I've been meeting fairly frequently with Monica Weaver from Crime Research Group, and we'll also be getting her and Robin Joy's insight on the data we're collecting and also how to report it and how do we measure outcomes. We do collect survey data, sort of satisfaction or feedback from victims and people who commit crime, and it's hard to get a good response rate there. It's hard to get people to complete surveys.
Thank you.
I think just, again, I really appreciate many of you sitting around this table being pivotal and getting funding for this program. And I'm really excited to really be having this launch. And I feel like we're going to really build on some solid foundation that has existed for years. Feels like really good work. And I do think that as we demonstrate the effectiveness, that law enforcement and state's attorneys will turn increasingly to this option.
Good transition to our state's attorney. Again, Kim, you're up. And is Kim probably coming up with you too? Good. Well, welcome. If you could both identify yourself for the record, that'd be great.
Tim Leaders Dumont, State's Attorneys and Sheriffs for the third time today.
Yeah.
Hello, everyone. I'm Kim McManus, the Legislative and Policy Attorney for the Department of State's Attorneys and Sheriffs.
So just starting off context-wise, yes, a couple years ago, we had spent a lot of time in particularly Chair LaLonde's committee talking about this option. Backing up a little bit, regardless of codification, a lot of pre-charge activity was happening in some counties, and then even more informal, what I would call deflection practices. I engaged in those often here in Washington County. Tell them that you're going to check back in a week, right? Me talking to the officer, neighborly disputes, disorderly conduct, graffiti, unlawful trespass, lots of things we informally deflect. Some version of codification has now come to pass. There is now both a pre-charge definition and a community referral definition. It probably falls more into the category I was just talking about. Maybe not a full-on finding of probable cause, but a police interaction, probably a VALCOR incident report generated by the officers. And so keeping that flexibility is very key to prosecutors' improvisational work with police to keep an even larger volume of cases coming at us that can be resolved at the community level. And sometimes it's as simple as, please go talk with this person about paying for the broken door. I'll talk with the victim next week if the door is repaired. So we still have that problem solving approach regardless of statute, rest assured. We've published all 14 counties now have published pre-charge. I relabeled the website restorative justice policies. Some of them cover a larger gamut than just pre-charge. And those are all published. We have ensured that, those are really in compliance with statute. Some of them are much longer. Some of them are quite brief, like case-by-case analysis, and violent instances are not considered. State's attorney and smaller counties, smaller law enforcement activity. So those are interesting. They're published on your page as well for you to have as a record. They're also on our website under restorative justice policies. And those were, a good iterative process. I was involved in the creation of a number of those. Some of the state's attorneys already had a policy in place and may have updated it to a certain degree. Bennington County had a longstanding youth policy that has been very effective for the last couple of decades. So that was already in effect and will remain in effect. In terms of how things rolled out, I will say with a lot of due respect to very limited resources, 2 counties that have published policies by the state's attorney, Orleans and Rutland, did not receive funding, I believe, for the programming side. And so that'll be a gap in the data from our perspective, right? Those 2 state's attorneys are not going to probably be sending much. So that those are just 2 asterisks, right? To just ensure that you have Rutland and Orleans. And I will say those state's attorneys were disappointed, right? Statewide program rolling out. And from their perspective, they had done the work to be ready to receive that type of programming. So that I wanted to put that out there. If I think I summarized that aptly. And then Kim has really taken the lead in working with Willa's operation and the new hire, and welcome. And really engaging with the state's attorneys. We still are a department, unlike many other departments. I'm so jealous when I'm hearing the Department of Corrections. I know I'm saying that out loud. They have a training academy, right, for people doing really important work. We don't have any full-time trainers. We don't have any full-time staff doing training activities, so we do it amongst ourselves. So there is no dedicated person who will be training law enforcement about this when it gets rolled out. So it'll happen as it happens with our department, probably on an ad hoc basis. And so that, just to put it out there, is out there on the table. Some states' attorneys are going to actively utilize this. Other states' attorneys, law enforcement may bring it to them saying, hey, this might be a good one for not a filing, but maybe this thing we've heard about. So we'll see. Couple years down the road, we'll have a better idea of utilization in the counties that weren't doing much of it before. And maybe can fill in all the gaps that I've clearly.
Tim has said a few of my comments already.
Oh, sorry.
So that's all right. But yes, we are going to continue to work with the Attorney General's office. Willa and now Kelly have reached out to us as Willa said, as they're building this plane while flying it, to check in with us on matters that we can have input on where we can, especially around the victim notification piece. One of the pieces in the bill is for our victim advocates to be consulted. And we will work on arranging that so that they can help in whatever way they can. And yes, essentially, since this has not rolled out yet and it's starting in bits and pieces, we're going to reserve our feedback for when it is fully operational statewide. And then we'll be able to weigh in on how we're seeing the effectiveness, especially in regards to pre and post charge.
Are you finding that there is buy-in from your state's attorneys for the pre-charge?
Yeah, I think we, every available tool, we have to come up with a different term, but that we have is something we're going to utilize when appropriate. So the providers, and you'll hear from Becky, who's a real leader, they're going to be one of the first entities to say to us, absolutely not for this person. This person has failed out of post-charge 5 times. This person has failed out of the pre-charge attempt. So they're not appropriate for this program. And that level of feedback and information sharing from the actual providers, because sometimes the state's attorneys are going to be like, oh my gosh, I don't want to prosecute this person again. It's never going to get to trial, all the backlog issues. Can we try to do pre-charge? Can we try to do post-charge? Can we try to do something else? And sometimes it's the providers who have every right to say, not this person again. I had a person that I thought was a good candidate for post-charge and a really good program here in Washington County. And Tim, that individual was engaged in a little bit of distribution in the parking lot on the way over. So probably not a good candidate to come back and not a good person around the diversion office as well. So that type of feedback from the local providers is really what the state's attorneys are going to, take their cues from, and they work really closely with them now, particularly where the combined offices, the combined CJC diversion post-charge offices, the ones where there's multiple CJCs or a post-charge and a CJC, there's going to be more of a learning curve and a communication curve with the state's attorneys on that. And some of those are changing, as Willa can tell you as well. But we obviously hope for statewide access as an option. Whether or not it's utilized or not, we'll see for sure. And the data piece is going to be very important, and we're excited to see that in a standard fashion, because the post-charge data has been very good for such a long time. The pre-charge data, as Willa knows, it was not collected by a uniform metric system or even input. And so it was all over the place. So once we have that, we've got the manual, here's how you send us data, and every county has access. That'll be a good point to then say, how are we doing with this? How often, how many cases did we prevent from moving into the system? So, yes.
So, yeah, so just as critical it seems as the law enforcement buy-in. And I understand the training concept, you don't have the ability to train, but it seems that some states' attorneys might be more enthusiastic in trying to work with law enforcement. Are you to try to do the free charge? Are you finding that, or is it too early to tell again?
Kim can talk more about some of the policies are actually drafted in such a way that it gives more discretion even at the law enforcement level. Like Kim.
I think if you have not already looked through the policies, you will see a range of how much the state's attorneys would be willing, sort of before knowing more details, what cases they could divert to pre-charge. Some state's attorneys are going to want to weigh in more case by case. Those tended to be the smaller counties, I would say, in general. I think, and we discussed this with the Attorney General's office, until we know what the charge is doing, like that, there needs to be the back and forth of seeing what goes there and the results that happen, and that trust building between the providers. And as Tim said, knowing where the limits are and knowing that the provider will express those limits to the state's attorney, this is not a good case for us. We cannot take this on. This is better for this kind of diversion, if that's what you want to do. That will take time as the program develops. I think big picture, this is a tool that every state's attorney utilizes in some way, shape, or form. So it's not the buy-in of the concept. It'll be the programs being set up under this bill, whether they're doing the work that the state's attorney hope they're doing.
Yeah, it seems like the interaction or the relationship between, well, my Chittenden County experience is that we've had some police chiefs who've been very supportive of this and worked really closely with the state's attorney. And dozens, if not hundreds of cases have been solved through that process. So, and I'm not sure how much one can encourage that as opposed to helping it along by providing these resources to make it work, hopefully.
And I think that's the key point. So if it's a select board that is the governing body of a small municipality with a police department, right? Doing outreach to that select board, who is then setting, hey, what are we doing about these low-level cases in the community here? Graffiti cases, select board issues a whereas cases involving graffiti in the town of X shall be, law enforcement should talk with the state's attorney about pre-charge. Right? So the different agencies and who governs their activity and their employment, really. VSB, right? You know who to go for that. sheriffs, 14 of them. And then it's the municipal agencies that'll be a little bit more interesting in terms of the piece here. And they have different levels of resources too. So, yeah.
This is a good segue to Becky, not Peggy, Becky, who is really the boots on the ground with up in Burlington, with, I want to say the Burlington Community Justice Center. So welcome, Becky.
Thank you so much for having me today. I appreciate the invitation, and I am wearing boots today. So I am Becky Penberthy. I'm the Restorative Services Program Manager at the Burlington Community Justice Center. I have some stuff written down, and I'll go through this with you all, but stop me. I'm happy to answer any questions. So Burlington Community Justice Center has hosted a pre-charge program since 2004. I've been here almost 4 years now. Before that, I was at Lamoille Restorative Center for 16. This year, from my Burlington, Chittenden County perspective, it feels a little different. Willa talked earlier in her testimony about a statewide committee made up of program directors and direct service staff focused on this pre-charge transition. I really am appreciative of our committee because we have representatives from Windham, Windsor, Addison, Caledonia, and myself from Chittenden County and another person from Chittenden County serving on that committee. So internally at the and across all programs, we're working to develop common practices and shared forms. You know, like earlier, there was a reference to the form. Everyone wants these forms. I'm told I think they're going to be live tomorrow, which is very exciting because I've talked with some law enforcement folks recently who are very interested in starting to use these forms. And at the same time, we're focused on sort of integrating pre-charge diversion into those existing programs that we have, YSAS, that the underage drinking ticket program, and cannabis possession, post-charge diversion, Tamarack pretrial services. So it fits nicely in those cohorts locally. Here in the county, we're collaborating with law enforcement, community stakeholders, and our state's attorney's office to support this transition. Yesterday, I spent time down at the Burlington Police Department. I've started to do some of that. I don't know if I would call it onboarding, but Tim talked about training. So I've started to do some of that onboarding with law enforcement officers, helping them to understand where we were and what the transition looks like. So under Chief Burke's leadership, I actually have a desk that I can sit at down at the police department, which is great. And I'm welcome at all of their roll calls so that I can at least have a moment with every single officer under his direction. And I guess from my perspective, that like the things to keep in mind when it comes to pre-charge, and other people have referenced some of these things, like the reduced caseload for our state's attorney's offices, for our public defenders, and for our court system. I kind of consider it like a low risk, high reward approach. If someone doesn't engage with the program, they still receive that citation to court, and their case can proceed through the traditional criminal legal system if they choose not to engage with pre-charge. I think the best part, especially for those impacted by crime, but for everyone involved, including the community, is that it's so fast, that it's rapid. Willa and Representative Lalonde talked about that. We can connect with victims and the person responsible very soon, sometimes within a day or two after an incident occurs. And I think that is the greatest impact here. But I have a little data from Chittenden County. Do you want a little data from Chittenden County? So
I would love data from Chittenden County, but let's ask the people from Windham, Windsor, and all the other places.
I know
Go
we
ahead.
have to get that, but this is just a little snippet. So so far, the countywide, we've received 184 referrals. The youngest participant is 13 and the oldest is 85. 25% are teenagers aged 13 to 19. That's the largest age cluster. 34% of participants are age 22 or younger. From there, The number of people at each age steadily tapers down, except we have a random spike with 10 participants who are 41 years of age.
41 years old or 41 and older?
41 years old, just 10 people of that 186. We have a 41-year bubble.
Are they males or females or a combination?
I think it's a combination, but I'm guessing based on my experience, it's mostly males. My apology.
No,
And then the top three sort of crime types, 35% are vehicle related. So that could be like excessive speed, leaving the scene of a crash, some sort of negligent motor vehicle operation. 21% are theft and property crime, and 14% are assaults.
That's right.
Yeah, so that's what I've gathered for you today, and I'm here to sort of represent the work that happens every day and answer your questions if you have any.
Questions, Martin?
So as far as the data points they have, do you have you have victim follow-up data as well, as far as satisfaction by the victim on those various successful cases?
So I can tell you that in each pre-charge case where there is where there are people who are impacted by that crime, outreach happens. I would be able to get you data at a later time to tell you how many of those we actually connected with, because all sorts of factors can impact that. Like the victim of the crime was somebody who was houseless, who didn't have contact information, and we couldn't find them by using another city resource to locate them or another county resource to locate them. Some people simply don't want to be connected with us, and we respect that. But in other cases, we do a great deal of work with impacted parties. What we don't get a lot of is that survey feedback. It's hard to get someone, like I get those when I go to the hospital, I get a survey in the mail or by email, and I have to say I never fill them out. So I think a lot of folks just don't fill them out. So we're always talking about, and through my tenure, we've always been trying to figure out how can we get like responses from folks to see, like, so we could change our practices if there was something that warranted that. But we're not getting a great deal of responses back. We absolutely do get some where someone sends like something critical that we need to attend to, or something where one of our staff did this amazing job and they felt incredibly supported and they send us a bit of a letter, but not enough to really inform us to the degree we wish we could use that information.
Understood. Thank you.
Anything else? I know the afternoon's wearing on. Thank you, Becky.
Thanks for having me.
Thank you.
We have one more item, and this one's gonna take some thinking a little bit. We have,
Thinking.
yeah, deals with ice. Ben's gonna walk us through the ice. I keep saying contracts. Contracts. Some is a contract, some is a rider. It gets really complicated because it's connected to Border Patrol and it's connected to federal law. It's really complicated. So Ben is going to do a quick review. Do have some documents that Ben has given us. The thinking is if we can get an understanding of some of this, and then in our October meeting, we'll have Jay Johnson here to go over the new rider.
No,
No,
kind of important.
I'm wearing down. I'm away on vacation, so I'm still kind of not here yet.
So for the record, for the second time today, still trailing, Executive Director Leaders Dumont, Ben Oversight for the Office of Legislative Counsel. So there are two contracts that involve, the Immigration and Customs Enforcement, and then a separate one, concerning Customs and Borders Protection. Which one is of interest first? I will leave it to the committee's discretion.
I don't care.
Okay, so the I'll start with the longer contract first.
That's this one.
Yes, so this is the one that concerns ICE. But it's not, you have to be very detail oriented to recognize that. So this contract is 18 pages long, and it's really between the Marshal Service and the Department of Corrections. The context for that relationship is for those offenders that are charged criminally in federal court. They're oftentimes transported by the Marshal Service, and they can use local facilities here to be detained. If you see on the first page of this document, in box 14, which is on the lower portion of the page towards the right-hand side, or not 14, I'm sorry, 19, which is the bottom of the page on the left-hand side, you'll see other authorized agency user. ICE is checked off. That has been referred to by members of the administration as the ICE rider to the Marshal's contract. That's really the only acknowledgement of ICE in this. But what this essentially does is that it provides them the ability to use Chittenden Regional Correctional Facility, the women's prison, and also Northwest State as the two locations to house immigration detainees.
Those two locations is what the St. Albans facility and Chittenden.
Correct.
And those are the only two
That are identified in this contract.
So the other one, BOP, that is border.
That would be Bureau of Prisons. And I don't have any knowledge of their use of this contract.
So this is with the United States Marshal Service. Did this get updated in general for the Marshal Service as well? Or was this rider added on to it specifically?
That's a question that I would defer to the Governor's Council. I did not have the prior iteration of this contract before this month, or last month rather. But my understanding is that the Marshal's contract was in effect previously. I'm just not, I just don't know what ICE's involvement was in that contract, if it was a rider or if they were added on. So I would defer that question to Governor's Council.
So like in block 9 on the front page, services, this agreement is for housing, safekeeping, assistance, care of federal prisoners in accordance with the content set forth herein, which is
Correct.
the rest of it. So this would apply to those detainees under the federal marshals,
Yes,
and it would also apply to those ICE detainees.
yes.
So then it goes to number 10, estimated number of federal beds would be for males and 20 for females.
Mhm.
So those 100 beds could be used for either federal marshal folks or ICE.
That's how I read this.
And then there would be a per diem rate of $185 for both federal marshal detainees as well as ICE.
Yes.
And then you've got the 13 box. Guard transportation hourly rate is 50.
Yes, that's for medical transports essentially.
So it would be our officers that would move those folks and then be receiving $50 per diem.
Yes, most of the responsibilities fall on the state rather than the federal government. And if you go through the contract in their obligations and responsibilities, including medical transport, where we essentially are reimbursed, additionally, kind of commitments by the state to uphold federal policies, federal law, to provide reasonable opportunities for detainees to obtain their own legal materials and confidential council. So the way that this contract reads is that these obligations on the state to uphold federal standards. But there's no mention of state standards in this contract that I've seen.
So if they say in testimony that they're abiding by state standards, how do we know that if it's not in the contract?
I mean,
That would be a question.
law does supersede contract. So, our facilities and our state officers are bound by state law. The contract itself, though, only mandates federal.
That would be a question that would need to be asked. So the only indication as to the renewal of the contract that expired in August is the check in the box here.
Well, so that's a different contract. So this contract is in perpetuity. There is no end date. However, it can be terminated by the parties upon 30-day notice, other considerations that go into it. There can be a termination fee that's levied, but succinctly, there is no end date.
Yeah, I got just one. Is this already signed by both parties and in effect presently?
I don't know that. There have been representations made that a couple of weeks ago that it was about to be signed by our federal counterparts. I just haven't seen the fully executed copy yet.
But the fifth floor has signed off on this, right?
Yes, Commissioner Murad has signed this.
The Commissioner Murad signed it on the 20th of August, but this doesn't show anything on the federal side yet.
Now shifting to the other contract. So this is a contract that was,
This is the MOU.
yes, the MOU that was often discussed last year. And
Is this in effect?
this is the one that expired in August. Has subsequently been renewed.
Okay.
And just to refresh the member's memory, it was flagged at one point that the title of this shows that this is between DOC and Customs and Border Protection, which left an open question of where does ICE fall into this whole equation. However, this is what was presented to us as the governing contract from my understanding. The Marshal's contract is what actually governs ICE. So I just want to make that distinction clear now. And Vermont, it's good to know as well, falls within the 100-mile radius from the border, and that is within Customs and Border Patrol's jurisdiction. So they're really responsible for that 100-mile ring, essentially, from our border within at ports of entry and things of that nature. ICE is what is within the country enforcing immigration laws. Vermont is almost completely overlapped by that jurisdiction. I believe that there is a small corner in southwestern Vermont that is only ICE jurisdiction and not CBP. So what this does is that this is a renewal of the previous contract that has been discussed this past session, except there are two distinct differences. One, the rate of compensation has been changed. What this contract now does is essentially create an escalating form of compensation. If you'll see on page.
Third page, second page.
That this is now at a fee of $180 per night per federal. I'm sorry, I'm looking at the old contract. My bad.
180.
Yeah, 185 from September of this year through July of next year, and then that slowly escalates over time through an outline date of July 31st, 2030. There is notation below that graph that for periods beyond the table, 3% increase will be applied. year over year. This also indicates the other difference between this contract and the previous iteration, which was the previous contract was only for a year. This one again is in perpetuity, which again can be suspended, revoked, or terminated upon agreement of the parties.
Where does it say it's in perpetuity?
It doesn't say in perpetuity, but the difference is if you see in clause 7 on page 3, a difference between this contract and the previous one is that the previous one actually had a statement saying the terms of this agreement will remain in effect for 1 year unless terminated by the parties. That clause is now omitted from the new contract. So to me, I read that as saying in perpetuity unless terminated by the parties. And I think that the compensation structure also supports that interpretation, seeing how it goes through 2030 and then has that 3% increase after that. Other than that, the terms of the previous contract are exactly the same. It was just a difference in compensation and in expiration.
Questions? So next, let's write myself down here. At our next meeting in October 27th, we'll have the administration here, so we can go in a little questions for this. So I would ask members to really pay attention to this and be prepared. And also, we did send a letter to the administration, really looking from the eyes of corrections and issues pertaining to corrections. And I'd like to know how to incorporate our requests into their new contract and their new MOU.
I mean, just again, substantively, the CBP contract is unchanged outside of those two terms of compensation and expiration. And I can't do a comparative analysis of the previous Marshall's contract just because I don't have a copy of it. However, there is that language of, if I may, reasonable opportunities specifically for legal materials, legal research, and confidential counsel. So that is incorporated into the Marshall's contract. But how that works out in practice, in contrast to what this committee sent or requested in the letter, I can't speak to.
Right. It's not your position to speak to. Okay, anything else? Tucker?
The letter that we sent, and I read the contract and I just reread the letter. It looks to me like there's language in there saying in terms of healthcare and so on, 24-hour notice. It sounds like they agreed.
Well, that contract, those provisions were in the previous CBP contract.
The 24 hours?
Mm-hmm. Yeah, all the medical care and things of that nature are identical. I just can't speak to the previous version of the Marshall's contract.
Okay.
Which is the one that actually governs ICE specifically.
Okay.
The one that governs ICE specifically
So Marshall's one.
is this one.
Correct.
So how does this play into this contract? That's where I'm having trouble merging these two. This is an MOU between U.S. Customs and Border Protection and the Department of Corrections.
Correct.
U.S. Customs and Border Protection also includes ICE? Or
No, they're separate agencies within DHS that have different jurisdictional roles, but their jurisdiction overlaps in Vermont. So,
It gets so confused.
yeah. So again, I would.
It's a 100-mile jurisdiction.
Yes, for CBP, but also ICE has the internal part of the country within their jurisdiction, and Vermont overlaps for both, for the majority of the state.
So which one drives what they do of these two?
Well, they have different missions.
Well, I'm thinking for ICE. Which one drives for the ICE detainees?
It would be the marshal's contract as far as I understand.
So for the ICE detainees in our facilities would be.
The larger of the two. And how they really interact as far as, correctional operations. I would defer to the department on that and also to the governor's office. About how they.
The MOU is saying, but this is where it gets so confusing, because the MOU allows the parties to house federal detainees, so that would be your folks who are coming across the border illegally. And they could be housed at all of our facilities.
Correct. Yeah, that's the other thing too, is that it opens up to all facilities statewide for the CBP contract. It limits it to 2 under the ICE contract.
That's under
The marshal's one, correct.
So it's really spending some time to understand, because I know the public, I know everyone's going to be focused on this. And I think we as legislators really need to be clear in terms of which document plays the part for the ICE detainees. So I think there's a lot of confusion there, because you have your federal detainee, your federal marshals, which are your federal detainees for someone in Vermont that has created a federal crime. They're under the federal marshals. Then you've got the immigration coming across the border. That's under your Customs and Border Protection. And then you've got this whole new arena of ICE detainees that are being held in some of our facilities.
Correct.
You've got 3 moving pieces here, and I think it's so easy for everyone to confuse it. So it's going to be really important for us and the legislative branch to really differentiate between these 3 populations and what the controlling document is. So it's going to be a lot of focus on this, whether we like it or not.
And this,
Can I just defer a moment?
No,
some of the stuff in here was different from the memorandum of agreement too.
this is for. This is for your Customs and Border Protection, but that also encompasses some of ICE. But the real ICE determinant is this. Yes or no?
I wouldn't say that's completely accurate.
Okay.
CBP, as I read it, is exclusively between DOC and the Customs and Border Protection.
For immigration issues.
Well, a different set of immigration issues. So for instance, those that,
The border.
correct, that's their primary jurisdiction.
So
They also have different operational abilities. Anything within 100 miles, traditional search and seizure rules don't apply. You don't need a warrant. You can go onto private property without a warrant. They, for lack of a better term, have carte blanche. That's why anytime you're crossing the border, they can search your vehicle sort of on a whim. ICE has different operational priorities and requirements. They're the ones, from my understanding, that use the detainer, which is a not necessarily a judicially ordered warrant. It's an immigration detainer. So they operationalize differently and have different powers and duties.
So this one here, that just from my,
Yeah,
this has nothing to do with us, right?
not from my understanding, correct.
Okay.
But again, how they're, to use the word again, operationalized in practice,
Yeah.
I would defer to the department and to the 5th floor about how they interact in practice.
Yeah, because the letter we wrote did have to do with us.
It didn't have to do with federal marshal detainees or immigration through custom and borders. It was it was our ICE detainees specifically. So we want to make sure, Megan, at our October 27th, we have fifth floor as well as deals at the same time. Because the fifth floor is one who negotiated it, DOC was not.
Nora, I look at this. We wrote this letter and we did specify that we're talking about border patrol protection and all that. We didn't even, I don't see ICE in here.
Well, and that was partially informed by the fact that, at least from my understanding at the time, I was not aware of the marshal's contract dictating the ICE relationship.
Yeah.
We haven't seen that contract.
Well, no, we have the new version,
Yeah,
but not,
The old.
I don't have the prior one.
So that would be something, Megan, to ask for the administration to also provide us with the previous contract. We could compare.
Everything clear as mud?
Yes.
That's exactly.
Well, the previous,
So when we look at it, Madam Chair, we're looking at it based only on the present contract compared to the previous one.
with the federal marshals,
Yeah,
this one, this is your federal marshal contract. We want the one that was previous to this. But we can just compare, that's all. We have to know what changed and what didn't. And if you don't have a copy of the previous contract, you can't see what the difference. So was the only difference, maybe they checked off that block of ice that said ice or not, we don't know.
Possibly,
We just,
probably not.
or there could be some items, language in here that was different that we just don't know.
I didn't even know this other one existed.
Anything else before we finish it?
I think one thing worth mentioning though about the ICE contract, if you look at it, there are a lot of references to the year 2021.
Yeah.
That's an indication to me, but I cannot say with certainty that this actually might be the only version of the contract, especially since it's in perpetuity. So maybe there wasn't a new version of the contract per se. And this would, what we're looking at is the
They
contract
must,
as it's existing.
they must have something with its signature here on the
Yeah.
date.
They initialed it.
Right, I mean, it was obviously renewed. My understanding, especially from the testimony from the department, is that payment was changed.
Right, right.
But as far as other more substantive provisions, I can't say.
It was signed on 8/28/25.
Yeah, that's the plan. Anything else before we finish up? So we are done. I know I went later than what we